There's a lawyer on your block who's retiring soon. She's got a thriving caseload, a name people know, a phone number that still rings, and absolutely no succession plan. What happens to that book? It evaporates. But here's the move: before it dissolves, you buy it. And we're talking about the cheapest growth you'll ever get. I'm Michelle Rotella, Senior Account Strategist here at Abogados Now. We've worked with over 500 law firms nationwide and driven more than $250 million in settlement fees. And we're a Google Premier partner, putting us at the top 3% of agencies in the world. We work with firms buying and selling practices every quarter, so we see exactly what works when these deals come together. Let's start with the reality. When solo and small firm attorneys age out, most of them have never planned on who takes over. Thomson Reuters' State of U.S. Small Law Firms report found that succession planning is a goal for less than a quarter of law firms. When that lawyer decides to retire, the clients don't transfer themselves. The active caseload, the referral relationships, the goodwill, all of it just walks away. That's the opportunity everyone misses. But you don't have to let it vanish. You can acquire that practice before it dissolves and walk in day one with cases already in the hopper, referral networks already warm, and a phone that's already ringing. Here's the core insight: you're buying demand, not manufacturing it. No ad ramp, no SEO wait. The cases are there. The relationships are there. You step into an existing revenue stream. When you acquire a practice, you're getting the pending cases with fee value still to collect. That's real money coming in after you close. You're also getting the phone number people already call and the website that's already ranking. Calls and inquiries keep coming without you rebuilding it from scratch. You're not buying one thing, you're buying a complete functioning book of business. That's what you'd otherwise spend years assembling. Here's the thing that surprises most people: it's often way less scary than the sticker shock suggests. Here's the kicker: for a contingency or PI book, a huge chunk of the purchase price is really just a fee share on the pending cases. You finish the work, collect the settlement, and split the fee. You pay from the cases themselves. The typical deal is a mix: some cash at closing, usually half to 70% of the price, seller financing for another chunk, and an earnout tied to how much you actually collect from the seller's existing matters. That means cash at risk up front is low. You're paying out of money the cases produce over time as they resolve. You don't write one terrifying check. Look, every deal is different. What you pay depends on the book, the market, the lawyer, the referral stability. Talk to an M&A advisor before you commit to any numbers. So now you may be wondering, what does getting a second book of clients actually look like? The retiring lawyer personally introduces you to her clients. She tells them you're taking over, that she trusts you, and hands you the phone. Now, it seems simple, but ethics still apply. Under the ABA model rules, clients are not property. That's self explanatory. They have rights, and you have to follow them when you get a new client assigned to you. The seller gives written notice to each client about the sale. The client gets 90 days to object or request that their files be transferred elsewhere. They have a choice. And here's the hard rule: you cannot increase fees on any client just because the practice changed hands. The fee stays the same, or you renegotiate openly. That's non negotiable. State bars have their own rules on practice transfers. Some are stricter than others. Talk to your bar or ethics counsel before you sign anything. We are reporting what's out there and how these deals typically work. For your specific deal, you need your attorney and your bar's guidance. That's the only way to get this right. Most firm owners spend all their energy worrying about succession, who will buy them out, what will happen to their book when they're gone. It's the exit strategy they lie awake thinking about. But here's the move: don't wait to be bought. Buy. Small tuck ins of retiring practices can be faster growth. You're not manufacturing clients from scratch. The cases exist, the relationships exist. You're just moving them to your name. This isn't a mega deal with scorecards and investment banks. It's a conversation with a retiring lawyer about moving her book to someone who will take care of it and her clients. Buying a practice that's already producing cases, keeping the clients and the staff, and scaling the work you inherit. That's growth with a head start, and sometimes the secret unlock to double the revenue without doing double the work. If you're looking at building the marketing infrastructure to grow your law firms, book a call with us and let's walk through the best Hispanic digital marketing plan built to grow your revenue.